Today I'd like to talk about a number of medical malpractice defenses. This is what you'll hear from the doctor or hospital's lawyer. But before I get started, if you ever have any questions regarding a Northwest Indiana medical malpractice matter, you can always reach out to me. I am Guy DiMartino. So here you go. The first defense is, the first position that defendants always take is, I didn't do anything wrong. There is no medical malpractice. The hospital will say the nurses didn't do anything wrong. The doctor will say, I didn't do anything wrong. It was just a bad result. You see, because the first thing that you have to show in a medical malpractice claim is that the doctor or hospital staff deviated from the applicable standard of care. What does that mean? It means either they did something or they didn't do something that a reasonable, prudent healthcare provider in the same or similar circumstances would have done or would not have done. Would have done or would not have done. An act of omission, an act of commission. Doing something is an act of commission. Not doing something, like not referring to a specialist, is an act of omission. So that's the first thing. No malpractice. We didn't do anything wrong. Second thing that we hear all the time is, yes, you had a bad result, but that is a normal risk and complication of the procedure. Look, your client signed this informed consent form. It says they can have anything that can happen in this procedure, including death, blood, you can become paralyzed, this can happen, that can happen, that can happen, and you can die. So the second most common thing that we hear is, yeah, there was a bad result, but that's just a normal risk and complication of the procedure. Therefore, no malpractice. Third thing that we hear all the time is, yeah, maybe something didn't go right. Maybe there was a little negligence going on, but it doesn't make a difference. That's the it doesn't make a difference defense, or the so what defense. And what that really goes to is the legal element of causation. And this would be a typical scenario. Say you have an underlying orthopedic injury. For instance, you have a severely broken ankle, doctor has to go in and repair the ankle, and then they have to do an ORIF, which is an open reduction internal fixation, and you do not end up good. You end up maybe even worse than you would have been if you didn't have the surgery. You believe that there was medical malpractice, and the doctor says, or the doctor's lawyer says, so what? You can't tell the difference if it was the underlying medical condition, the broken ankle to start with, or if the negligence or breach of the standard of care actually caused the outcome, whether it's the need for a second surgery or a third surgery, whether it's the need to wear some brace, whether the person's in chronic pain. You can't show it. It's the so what defense. It's the causation defense. Even if there was malpractice, you can't prove that it was the malpractice that caused the condition that you're experiencing now versus the underlying problem. And we see this all the time in orthopedic cases. Why? Because the reason why the person had the initial orthopedic surgery was because of some underlying problem and some underlying injury. So there you have it. First thing is, we didn't breach the standard of care. No malpractice. Second thing is a little variant on that. Yeah, you had a bad result, but you want to know something, it was a normal risk and complication, therefore no malpractice. Third defense is the causation defense. So what? You can prove that what the alleged malpractice caused the problems that you're having now. If you have any questions regarding a Northwest Indiana personal injury matter or medical malpractice matter, you can always reach out to me. I am Guy DiMartino, meeting you at the intersection of law and medicine. Have a great day.